Good morning and welcome to our webcast today. My name is Surisha Gunta. I'm a staff attorney with the Pro Bono Partnership of Atlanta, and today we have Dan Kingsley from Swift Curry, who will be speaking to us about premises liability, which basically means what happens if someone is hurt at your facility. I want to tell you a little bit about Pro Bono Partnership of Atlanta before Dan starts talking about his subject matter. Pro Bono Partnership of Atlanta seeks to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. Our clients are 501c3s that are in or serve the Metro Atlanta area and serve low-income or disadvantaged individuals and otherwise are unable to afford legal services. Please go check out our website for more information, or if you're interested in becoming a client of ours, you can submit a request for legal assistance through our website. Also on our website, you'll find a wealth of resources, including articles and webcasts, including today's webcast, which will be housed on the website in a few days. And you can also come to some of our webinars that are in person. A quick legal disclaimer. Today's information will be just general guidelines for Georgia nonprofits. If you need specific legal advice for your organization, please consult with an attorney. And now, Dan, I'll turn the mic over to you.
All right, thank you very much. Good morning. My name is Dan Kingsley. I'm an attorney here in Atlanta. I work for a firm called Swift Curry, McGee & Hires, and I practice all types of civil litigation, which includes any time on the defense side where a business such as yours is sued for personal injuries, whether that arises out of something having to do with an injury at a facility, a product, an automobile or truck wreck. I handle all types of civil litigation on the defense side. And I've represented businesses like yours for several years now. I'm here this morning to talk about something that is specific to your businesses as nonprofit corporations: premises liability, and what can happen if somebody is injured on your premises or in your facility. A few things that I'm going to cover during this presentation include common situations that arise when, as a person is injured at a property, a premises, in a building, or one of your residential properties. Common hazards that we see routinely throughout litigation. I'm going to give an overview of Georgia law and what your responsibilities as premises owners or occupiers, what your responsibilities are to the people who come onto your property, in your buildings, or to your facilities. I also want to spend a good amount of time covering some practical considerations for you as a nonprofit business. What can you do to be proactive in trying to prevent incidents from happening? And once incidents do happen, what you can do to be proactive after it occurs to protect you and your business from any risk or exposure in the future. Lastly, I want to talk about litigation, lawsuits. Hopefully this is a topic that you're not all too familiar with, but I want to cover some of the basics here in Georgia and what you can expect if and when your business is brought into a lawsuit. Now, some common scenarios that happen at properties and premises and buildings, like the types of places where you operate your nonprofit businesses, are falls. We have people who come into your businesses who, for whatever reason, they may slip and fall, they may trip and fall. Those things happen. Now, there are certain hazards that we see that can contribute or add to that. We see floor mat incidents, people tripping on floor mats going in and out of buildings. We see falling objects. Many of you may operate warehouses for your nonprofits, and in those warehouses you may have shelving and product or items that are placed on shelves that are stacked and organized in a certain manner. When people come into your facilities, we've seen, and I've personally seen in cases, injuries that occur as a result of falling objects. Something falls onto somebody and injures them in some type of way. Another common hazard is what we call, in the legal world, foreign substances. A foreign substance, a substance on the ground that someone slips on. and it could be something that is water, it could be something that leaked out of a product. Think of your grocery stores, where you're walking in a grocery store and you notice something on the ground, such as fruit, or somebody knocks milk over, or a liquid, and that liquid stays on the ground, and somebody, unbeknownst to them, walks down the aisle and slips on that. We may not know at the time what caused the fall or the slip, but we know it was, as is alleged in cases that we handle, are foreign substances that cause the slip and fall. We also see slip and falls or trip and falls on natural substances. We don't get a whole lot of ice here in Atlanta, but when we do, it can be dangerous. As you've probably noticed, that this city in general tends to freak out whenever we have any type of cold weather hit, and there's usually ice that forms and isn't necessarily remedied right away. So when you're operating a business and something such as ice or water builds up, those are things that you should be able to look out as potential hazards for the people that are coming into your businesses. We also have what we call static conditions. Conditions that don't change. They're just a part of the property or the land. The best example of this would be either potholes or uneven sidewalk, uneven cement where there are cracks. Those can give rise to people having incidents, coming in and out of your facilities, things that aren't changing on an everyday basis, like a spill or something that falls on the ground, but something that is always there that we need to be cognizant of. Lastly, one of the most common hazards occurs when equipment is used. Many of you probably use equipment in the operations of your businesses, forklifts, or even golf carts, or things that you use, pieces of equipment to get product moved, to get people moved. Those things themselves can give an inherent risk of danger to people's safety, whether it's your own employees or people who are coming into your businesses or onto your property. Things that we need to be knowledgeable about, have our employees knowledgeable about, because even though the employees may be going about their business operating a forklift or other piece of machinery, we need to be aware of the fact that other people coming onto the property, our clients or our customers, may not be as familiar with those pieces of equipment, and that can give rise to an inherent a hazard that we need to be aware of. Now, Georgia law in most states breaks down the status of a person on your property into three different categories. The first one is called an invitee. An invitee is someone who comes onto your property for the benefits of the business. They're a customer, or somebody who's coming to your business for the purpose that your business is there. This is going to be the most common situation for your nonprofit businesses, dealing with customers who are coming onto your property. The other two categories are licensees, persons who are allowed to be on your property for their own benefit, social guests, or if somebody's soliciting for business or soliciting advertising. Solicitation in general would be a good example of that. The duty there is not to willfully injure a licensee, whereas the duty to an invitee, one of your customers, is a greater duty. It is a duty to keep your premises safe. And I'll get to that, but for now I just want to lay out the three types of classifications that Georgia law gives to people who come on your property. The last of which is a trespasser, someone who is not authorized to be on your property. Now the duty owed to them is to not willfully injure a trespasser. The best example, and this really doesn't come up a whole lot in Georgia law or probably everyday situations, is setting traps to injure them to prevent them from coming onto your property. We can't willfully try and injure people who are not authorized to be on the property. With respect to your duties as a business owner who either owns property or even occupies property, because many of you may own property, but you may also lease property. Georgia law provides in a statute that an owner or occupier of land is responsible for injuries caused by his failure to exercise ordinary care in keeping the premises and approaches safe. Now, in looking at that, that seems very broad, that an owner of land or an occupier of land or property has a duty to keep the premises and their approaches safe. Now, what does that mean? What it doesn't mean is that a premises owner or occupier has to ensure the safety of everybody who comes onto their property. You have to take reasonable steps on ordinary care to keep your place of business safe. Now, as this applies to nonprofit businesses, you may be thinking, is there a difference between a nonprofit business and a for-profit business? Unfortunately, despite all the good that you're doing in your community, Georgia law looks at all businesses the same in this respect, and all landowners and all occupiers of land. They are all even in this respect, and that there is a duty to keep the land, your premises, and your approaches safe. The premises being your land, your building, your parking lots, your sidewalks, those things that your customers and your invitees are going to be on, traversing, entering and exiting, all of those things. There is a duty to keep the premises safe. Now, when an incident happens, and we often see this, at least when I get involved, is when a lawsuit is filed against a business. And I've represented for-profit businesses, I've represented nonprofit businesses. It doesn't matter whether or not you're a for-profit or nonprofit, they all get sued. And so we need to be prepared for if and when that situation arises. Now, when a person sues a business for an injury, the person who is doing the suing is called a plaintiff. And when a plaintiff sues a company such as yours, they have the burden of proving that they are entitled to the injuries they say occurred and the damages, the money that they are seeking. Now, an owner or occupier, in order for a plaintiff to prove their burden, has to show that the owner or occupier possessed superior knowledge of the hazard they're saying caused their injury. Now, this is proven by a plaintiff in two ways. They can do it by showing that you, the business, had actual knowledge that there was a hazard at the time of the incident, or that you had constructive knowledge that you may not have actually known, but you should have known. Now, an owner should have or could have known of the hazard with a reasonable inspection. So, in other words, a business can't simply turn a blind eye or be ignorant as to the common hazards that may arise on their property. It's incumbent upon a business to have reasonable inspections or procedures or protocols in place to handle common hazards that may arise in the scope of your business. The plaintiff must also show that they had no knowledge of the hazard, or at least they didn't have the same amount of knowledge as the business. Once this is established, the owner or occupier then has to prove that the plaintiff failed to exercise ordinary care for their own safety. As you're sitting here, you may be wondering, in all these situations, does a person entering a business, does a customer entering a business, have a duty on themselves to use common sense and exercise ordinary care when going up the stairs or walking through a parking lot or looking down and walking to make sure that there is no hazard or substance on which they can fall? And the answer is yes. That is all part of this equation, and that never leaves the plaintiff. The plaintiff has a duty at all times to exercise ordinary care for their own safety. That doesn't prevent a plaintiff, however, from filing a lawsuit and claiming that the business had superior knowledge, or that the business should have taken steps to clean up a spill or to fix a pothole that they knew could have been a potential hazard. Now, how does a plaintiff prove that an owner-occupier had superior knowledge? Well, we talked about showing actual knowledge. This is actually very difficult to prove, because unless a plaintiff can identify someone who knew about the hazard, or there is some type of document or video that shows that the store or the company knew that there was a hazard in place and just failed to do anything about it, it can be very difficult to prove that. So most of these cases rely on whether or not the business had constructive knowledge, whether or not had they had a reasonable inspection procedure, would they have been able to identify the hazard. This can be done by showing that there are employees at the facility who were in the vicinity and should have easily picked up on the fact that there was a hazard. There can be a history of prior incidents, such as falls or incidents with the example I gave before where product falls off the shelves. If there is a history of those things happening and the business hasn't done anything to try and resolve that issue from continuing to happen, a plaintiff can use that to try and prove that the business had constructive knowledge that there was a hazard at the time. Plaintiffs usually focus on this and trying to show that the business should have known there was a hazard. It's much easier to make the argument that the business should have known there was a hazard rather than showing that you knew of something at the time and did nothing about it. Now I've talked about reasonable inspections. What is a reasonable inspection? There are several cases in Georgia at the appellate level that has looked at these types of cases and given a variety, a range of what a reasonable inspection is. In the Walls v. Walmart stores case, this is from 2005, Walmart had a policy of having its employees clean and check the floors of the store every hour. We call this the zone defense strategy, where you have your employees go out and every hour or at a certain time increment check to see if there are any hazards, if there's any spills, things on the floor, things that people can trip on. And if having this consistency every hour, the court found that that is a reasonable inspection procedure. Now, as I said before, a business doesn't have to guarantee complete safety at all times for the people who come onto the property, but reasonable steps, reasonable inspection procedures should be taken. Another case found that inspections every 30 minutes was sufficient. Another case found that every hour and 15 minutes was reasonable. One even found that every 2 hours was reasonable. So there is no bright line rule as to how often or the time increments between inspections. But the common theme throughout all these cases is that there is an inspection procedure, that it's reasonable in that it's reasonable to expect a business to have its employees check for things that might be hazardous in their facilities, depending on what type of business you have, and that those procedures are followed routinely. It's not just something that's put in writing, not into practice. It's something that is done and that your employees and the people of your business could attest to, that this is what the procedures are, this is what we've been trained on, and this is actually what we do. Now, the primary defense for a business like yours in a case like this is that reasonable inspection procedure. And I'll tell you, just based on experience, having a verbal inspection procedure oftentimes is not sufficient. It's not bad by any stretch, but it is a much stronger position to take in a case if that procedure is written and there is evidence that it has been trained on in its employees, and that the employees have been given the procedures in writing so that they can review and understand them. All of this is about trying to document a history of how reasonable your businesses are being with respect to addressing common hazards in the business. And so I'll tell you that having something in writing can go much further and can be much more compelling, either to try and get out of a case, or if you're standing in front of a jury trying to explain to them that what you've done is reasonable. Because things in writing are communicated often better than just verbally, especially since memories tend to fade easily over time. You probably have turnover with employees in your business, and having something in writing that is done for every employee and done on a routine basis can go much further in protecting yourself for these types of exposures. It's not, and I will say it's not sufficient enough to the court, at least, to have a reasonable inspection procedure. It must be actually followed at the time of the incident. You've probably been inside, and you may institute this in your own businesses, but you've been inside a restaurant or some type of business, and you've gone to the restroom and you've seen on the back of the door that there's a clipboard, and there's people who sign off on it every hour. The reason that is done is for this purpose, to show that something's been inspected, something's been cleaned, something's been confirmed to be hazard-free, and someone signs it, and it's well documented. These are proactive steps that you all can be taking now to protect against something or an incident that happens in the future. And it's not just to protect against if a lawsuit arises or someone makes some type of claim against your business. It's done as a good practical measure to prevent people from getting injured in your businesses. I mean, after all, you all have a mission in your communities to provide for the people who are coming into your facilities. We want to protect them and give them a safe environment to be at while at your businesses. But it also provides a secondary purpose of establishing that what you've done is completely reasonable. Other defenses we've talked about looking to the plaintiff and discovering whether or not they've exercised common sense and ordinary care for their own safety. I mentioned before that a business can only be liable if they have superior knowledge. Now, if the knowledge is equal to both the business and the plaintiff, well then it can't be said that the plaintiff gets to recover from the business, because the plaintiff knew just as much information as the business. You see this in situations where, for example, someone walks into a facility and they walk across that uneven pavement we talked about earlier. They've been into the store, they know that hazard's there, they had no problem traversing it or walking over it the first time, but on the way out, they trip and they fall. Well, that would be a good argument to say, well, you knew that was there because you walked over it the first time when you were coming into the store or the facility. So it cannot be said that you didn't possess as much knowledge as we did with respect to that hazard that you tripped on. Other things are open and obvious. You've probably heard that term, open and obvious hazards that are so open and obvious that anybody exercising any common sense or ordinary care for themselves should notice that this is a hazard, to be careful of that. Now the catch-22 and the flip side of that is it is so open and obvious and should be to somebody coming onto the property, it should likely be just as open and obvious to the business to somehow assess that and do something about it. So I wouldn't rely on the open and obvious argument. I would use it more as to assessing your businesses for those open and obvious hazards, because those are the things that should be the most noticeable and readily available to fix. Practical considerations for your businesses. Now I realize I do this for a living, and I handle lawsuits for my job. You all are not in the business of dealing with litigation and lawsuits and claims of injuries. You have your missions and you have your business plans that you execute every day. So this is probably not at the forefront of your mind, but there are small things that you can do in your practice and in your business that can really make a big difference in the future should your business ever get confronted with an injury or a claim to your insurance company or to your business or a lawsuit. There are practical considerations that you can do now to help minimize your risk and exposure. The first thing is, and we've addressed this throughout, is assessing any hazards you have at your business and on your property. We're in Georgia, obviously, and the weather here isn't as big of an issue as it might be in the north or the Midwest when you're dealing with the winter weather. But that means that when winter weather down here hits, your antennas should go up to be more cognizant of what that can mean for hazards at your business. Looking at the time of year, one thing that we see in cases is, and I'm not sure how late your businesses are open, but throughout the year, obviously, the sun sets at different times. The lighting is different. And if your businesses are open past daylight hours, looking at the lighting that you have in your facilities, in your parking lots, in the areas where people are going to and from their cars and into your business, looking at that, being cognizant of lighting and visibility. Looking at the types of businesses that you have, whether or not you're dealing with products, whether or not you're service-based, and seeing what are the things that are most common that people coming into your facilities and businesses, what are the things that are most commonly going to present a hazard to them? And seeing that now and trying to be proactive about preventing that, whether that's understanding the type of machinery and equipment that your business uses on an everyday basis, and educating the people who are using that equipment to be on the lookout for people who shouldn't be there, or having procedures that prevent customers from getting anywhere near the equipment. These are all things that seem simple because if they're hazards, a lot of them to us seem open and obvious, but it's never a problem until it actually happens. And so if we can just step back and assess our business to see what are the hazards and try to do something about that now, it can really make a big difference.
Excuse me, can you have a question in terms
Yes.
of assessing hazards? What sort of responsibility does an organization have for the sidewalks that are outside of their facility?
As far as the sidewalks, Georgia courts have held that sidewalks that are immediately adjacent to your property, and going back to the statute uses the word approaches. Approaches includes those sidewalks that are between your business and the parking lot, which you may or may not have any control over, but the sidewalks fall within your responsibility as the business to make sure that the customers coming in and out of your businesses, that they have a reasonably safe sidewalk to get to and from. That's a good question, because a lot of businesses lease their stores or their facilities, and a lot of times the landlord is out of pocket. They may be out of state. They may not have a whole lot of involvement in running the property itself, and it's incumbent on the tenant, you all, who may be leasing the premises, to make sure that your sidewalks are relatively and reasonably safe. That may give rise to contacting your landlord or the property owner to remedy or to assess and fix things that you can see on your property, particularly with the sidewalks. Those are things that you should be aware of, and sidewalks are part of that.
Okay, thank you.
When an accident happens, and some of you may have encountered this in your businesses, but what should you do when an accident happens from a practical standpoint? The first thing that I've learned in handling these types of cases is that the more information we can get right when this happens, the better off everybody is later on. Because it's not at the forefront of your business and of your mind when you're doing your daily operations. It may happen. It may be the center of your attention for a couple of hours, one day, a week, and then after that, it may go away for some time. But when it comes back to it or arises again, I've seen time and time again that had little things been done right after the incident to investigate everything that happened can make a big difference to figure out what happened, why it happened, and who was responsible. Now, the first thing is to investigate the accident itself, to investigate who the person is who fell or tripped or was somehow injured on your property, to get their name and their information, and to get their side of what happened, why it happened. In the example of a slip and fall on a foreign substance, doing some type of investigation as to what the substance was. How did it get there? How long had it been there? All of those things documented and preserved at the time so that we have that information are going to be very important if this ever gets to some type of claim or lawsuit later on. Now, I'm not sure if your businesses have surveillance or security cameras or any other type of incident reporting type of procedure. Whatever you do now, it's important to understand that when you do something, that you retain that information. It's good to take photographs, and it's good to get statements and the names and contact information of witnesses, be that your employees who are on duty at the time, the person who fell, slipped, was injured, and anybody else in the area who may have been around. Because once everybody disperses and leaves, we may never get a chance to talk with those people again, to see what actually happened and to get their account of the story as it actually happened. Memories naturally fade over time. Details that are important at the time of the accident, those become blurred as time goes on. So we want to get a full understanding at the time of an incident, what happened, why it happened, and who all was involved. I would recommend trying to get all the names and contact information for anybody who witnessed an incident, anybody who was there as your employee at the time of the incident, because as you know, there may be turnover, and an employee who was there at the time of an incident a couple months from now may no longer work for your business. And it may be hard to get in touch with them unless we have their contact information and we have an account of what happened. It's important to preserve all evidence. If you do have surveillance or security footage that could have picked up an incident, save it. I can't stress enough that if you do have camera footage or photographs, you need to preserve it. It is very easy. I've seen countless times where businesses, they have surveillance footage, and it's not necessarily for this situation, but you have it nonetheless. And most security cameras, they just roll over, they continue rolling, and they tape over past footage. It's important to, when an incident happens, to go to your camera system to see if it captured anything, and if it did, to pull it and preserve it. Because if you don't do that, it's going to be argued later on that you had a chance to show what exactly happened, and you essentially got rid of the good evidence. And people will argue that the reason you got rid of the evidence was because it was harmful to you. So it's important, good or bad, to preserve all evidence that you have. Many of you, I would think most, if not all, of your businesses have insurance, general liability insurance. It's important that when an incident happens that you report that incident, whether or not somebody has mentioned at all they intend to file a claim or file a lawsuit or anything. It is important to notify your insurance company just so everybody is on the same page, so that there are no surprises, and that so you've done your duty to inform them of a potential claim. Now, the reason I do want to stress, the reason we do some of these things is to learn from them so that we can improve our businesses so that these things don't happen in the future, as well as to minimize any exposure that may happen. Now, that doesn't mean that when an incident happens you can't be absolutely courteous and polite to the person who may have fallen or have been injured. It is okay to ask them how they are, if they are hurt, if they are injured. All of those things, the human aspect, all of those things are good, and you should do those things and be courteous and polite. And if they want you to call someone for medical attention, it's okay to do that. So just because in the back of our minds there's always this potential for a claim or a lawsuit doesn't mean we can't just go about doing what we would normally do and being polite and courteous at the time.
Dan, a question about preserving evidence.
Yes.
How long is there a requirement for how much time you have to hold on to it?
There is no requirement for the time you have to hold on to it, but I would hold on to it indefinitely. Okay. If the insurance company, when you report it to your insurance company, they will likely ask if you have any evidence. And so it's good to provide all that evidence to your insurance company. Sometimes you may have an attorney involved. You may have an attorney that regularly handles this type of thing for you that you have experience with from past incidents or lawsuits. if you have an attorney assigned or retained to help you with that, it's good to give them all the evidence, because it's just one more person preserving the evidence. We want to make sure nothing happens to the evidence, because just out of an abundance of caution, we want to make sure that we have all the information about the incident. And the reason, moving on, the reason that I'm trying to stress this as much as I am is because of this thing in the legal world that we call spoliation. Spoliation is the destruction of or failure to preserve or significantly altering evidence that is necessary or material to pending litigation. We have a duty, businesses have a duty to preserve evidence where there is a potential claim for injury. Now, the primary goal of spoliation is to put a duty on persons and businesses to preserve evidence that can help identify or explain the incident that happened, the people involved, the incident involved. The goal of spoliation, this line of cases in Georgia, is to preserve evidence, because everybody is better informed and is better educated about a case where we have all the good evidence. The secondary goal is to impose sanctions or penalties on parties who, knowing they have a duty to preserve evidence, nonetheless get rid of that evidence. And it doesn't have to be something that's purposeful. It doesn't have to be purposefully destroying a video that you think is harmful to you. It could be just not preserving it, letting the camera footage keep recording and roll over the footage that had been taped of the accident. It could be not saving the records or the witness statements that people gave you, putting it in a file, and every 6 months, just as a matter of course, getting rid of files. It could be just sort of that failure to preserve, where you know that there is a potential claim out there. Now, the court looks at these situations very seriously, and some of these, they range in severity. So in the most extreme circumstance, the court can dismiss the case against a business and automatically grant essentially a victory for the plaintiff, because if the court finds that a business acted in such bad faith and used such bad behavior to get rid of evidence, that the court finds that this is the only way to effectively punish a party for doing something, if the court finds that it was that egregious. Now, that is very rare. That is the most extreme circumstance. That's not to say that's not happened, and I've seen that happen, but those circumstances are very egregious. What's most commonly done by courts, if that happens, is the last one, is an adverse inference charge to the jury. And what that means is that the court can explain to a jury that business A had video footage of plaintiff falling in their store, and business had the chance to preserve that camera footage, but for whatever reason did not. The court can instruct the jury to take that as meaning that the reason the business didn't save the camera footage was because it was going to show something that hurt the business. So that's what we call the adverse inference charge, where the other party gets the benefit of this adverse inference. Now, we can say, well, no, that's the reason we actually didn't save it was because we didn't think to save it and we accidentally let the cameras roll over. But the jury is still going to hear from the court that they can take that as meaning the reason you didn't save it is because it was going to hurt you. Now, there are, I won't go through all of these cases, but this is just to give you an idea that this is a matter that is very seriously taken by the court. It is something that we do end up handling very regularly. Because as I said earlier, small steps can be taken when incidents happen, that can be very effective for future litigation if that happens. Not taking those small steps, though, just little things like saving photographs or a camera video, they can have big consequences. So it's better to get ahead of this on the front end rather than try to play from behind on the defense later on if someone tries to accuse your business of failing to do something it should have done. And it's not, as I said, something that is necessarily purposeful, but more just being cognizant of it at the time for your business to get ahead of it at the time of an incident. Now, what happens after an incident occurs? After you've done your investigation, after you've talked to people, you've gotten contact information, you've taken photographs, you've saved the camera, you've reported to your insurance company, you're going to find that these things can drag on, and it can be months until you ever hear about this again. And you may go a couple months and not hear anything, and you may think, okay, everything's fine, and then a year or two later, it can rear its ugly head. You may get a letter of representation in the mail. And usually that is from an attorney that the person injured at your facility or your business, they've gone out, they've gotten an attorney to represent them. And that attorney turns around and they send you a letter. And the reason they send you a letter is for two things. The first is because they want your insurance information. They are entitled, under Georgia law, to ask you to give them the name of your insurance company so that they can notify them and so that they can check to see whether or not you have insurance. The second thing is what I've harped on for the last 10 minutes, which is they're going to tell you to preserve all of your evidence. And they are doing that so that, A, you preserve it, but B, so if you don't preserve it, they can look back at this letter and they can say, we asked you to preserve everything, and you failed to do it. And that is, it's not a setup, but it allows them to go back to the letter and say they knew this was a serious claim. They knew this had potential to go into a lawsuit, and we notified them. We put them on notice that they needed to preserve everything. And then the burden shifts to the business to actually show that it preserved the information. When you get this letter, you should forward it to your insurance company. If you have an attorney at the time, you should forward it to your attorney. And at this time, you should know that you should not contact the injured person at all. You should not contact the attorney. You should refer this to your insurance company or your attorney to handle this on your behalf. Now, what happens if this case goes into a lawsuit? Under Georgia law, a person who is injured has 2 years from the time of the incident to file a lawsuit. Now, 2 years can seem like a lot of time. And in your world, as I just mentioned, you may deal with this in the day of the incident for a couple of hours, and then you may refer it off to your insurance company, and that may be it for a year, even maybe 2 years. And then all of a sudden, you're served with a lawsuit. And it seems sort of unreasonable that all this time has gone by, and now, 2 years later, the person is filing a lawsuit. Under Georgia law, they're entitled to do that, and there may be things that are going on in the background that you're not necessarily privy to that may give rise to the reasons why they've waited the full 2 years, such as if your insurance company is trying to resolve the claim with the attorney for the injured person, or the insurance company is doing some investigation on their own that they're simply not keeping you informed of. It's not unlikely, and we see it all the time, that 2-year date, just even a couple days beforehand, a lawsuit is filed and it's served on the business. Now, this is typically a hard deadline, 2 years, but they just need to file a lawsuit. Now, when you file a lawsuit, there are two things, and hopefully I'm giving you somewhat new information that you're not entirely knowledgeable about this process, because I would hope that you all haven't had to spend a lot of time in lawsuits. But when a lawsuit is initiated, it is done so by filing what we call pleadings with the court. A summons and a complaint. Now, the summons identifies who is being sued and where their business is, so that someone, usually a marshal from the marshal's office, can come and personally serve the lawsuit on the business. It's also done with a complaint. Complaint is just a fancy term for the lawsuit. This is usually multiple pages, and it usually goes through in details all of the facts and the claims that the plaintiff is making against your business. Who they are, when the accident happened, maybe how it happened, and why they are taking the position that your business is liable to them. As I mentioned, you must be personally served. Now, your nonprofit likely has a registered agent. The registered agent is the one who gets served with the summons and the complaint, and that is personally served. Now, you may have designated a registered agent, a company to receive it on your behalf, or an attorney to receive it on your behalf. So when that registered agent who you've designated, they are served personally with the summons and complaint, now the time starts clicking as far as what your obligations are. Once the lawsuit is served, the defendant has 30 days to file an answer to the complaint. That is a way to go through each allegation in the complaint and provide a response to it. Either we agree with you, we disagree with you, we don't have any knowledge of the claim you're making. It's a way to address each and every statement that they put in the lawsuit. They may also serve you with what we call written discovery. This is a way for the other side, both sides can use this, to try and get information from the other side about the incident, about the parties involved. And a lot of times when a defendant or business is served with a lawsuit, it'll come with other documents that are called interrogatories or requests for documents. Now, interrogatories is a fancy term for questions. There'll be a list of questions that the plaintiff asks the business to answer. And you get 45 days from the date you receive the lawsuit to answer those questions and to provide the documents that they ask for. One other set of written discovery is a document called requests for admissions. And these are just a list of statements that the plaintiff is asking the business to admit. What's important about requests for admissions is that they are timely responded to. Because if you don't respond to the request for admissions when they're due, then everything that the plaintiff puts in those requests is deemed admitted. And most of the time, all the requests are basically stating, admit you are responsible for my fall. Admit you knew this substance was on the floor prior to my fall. All the things that are helpful to the plaintiff and harmful to the defendant. So it's important that we address each and every one of those as dictated by the time requirements. Now, where will the lawsuit be filed? The lawsuit for nonprofit corporations has to be filed where the nonprofit maintains its registered office. This may be your principal place of business. Or it can be in any other place where your nonprofit has an office, if that is where the accident happened. Most of the time, it's going to be where your registered office is. In Georgia, I have on here a venue map of what we've determined are some of the most conservative to liberal venues. Here in Metro Atlanta, we have some more plaintiff-friendly venues, such as maybe Clayton County or DeKalb County. And as you start to move out of the metropolitan areas, you get into areas that we think are more defense-friendly. They're more nonprofit or even for-profit friendly to defendants. Now, in order, we've talked a lot about what the plaintiff must prove. Plaintiff, when you go to court for a lawsuit, in order to prove that a defendant such as your business is negligent, the plaintiff must prove that you had a duty, that you breached that duty, that the breach of the duty caused the damages and the injuries that the plaintiff is seeking. They must do that by what we call a preponderance of the evidence to recover any type of compensation or damages from the defendant. Now, preponderance of the evidence, now we've heard in criminal cases, you may have heard beyond a reasonable doubt. That is a much higher standard than preponderance of the evidence. If you want to think about a football field or scales for preponderance of the evidence, all the plaintiff has to do is tip the scales a little bit in their favor, and that shows that they've reached a preponderance of the evidence. They just have to make it across the 50-yard line. Now, if they only make it to the 50-yard line, if it's 50-50, well, then that tie goes to the defendant. So the plaintiff has to meet the threshold of getting across that halfway point. Now, what types of damages will plaintiffs in these types of cases seek from a business? Well, they will seek general damages, which are presumed to flow from any tortious act, from any act that causes injury. Those types of things are pain and suffering. That's what we typically consider general damages, the pain and suffering that a person will state that they have gone through as a result of the incident and their resulting injuries. Now, we also have what we call special damages. These are the things that are more black and white. Special damages are their medical bills. If they claim that they have lost wages, they've been unable to go back to work, or they missed work. Things that you can show with bills or records or testimony as to how much money they claim they are owed. We also have property damage. If somebody's property is damaged, that's typically the easiest to show through appraisals, or you can try and determine the loss in value of a certain piece of property. So these are the things, the special damages, that are more black and white that we will find out throughout this discovery phase. Now, for the first 6 months after a lawsuit is filed and after you answer, the 6 months following when you answer the lawsuit, we go into this period that we call discovery. And that's a period of time. It starts out as 6 months in Georgia, and it often goes beyond that, but we start out with 6 months to start. And that's a period of time that the parties can discover all types of information from each other. As we already talked about with the interrogatories, the request for documents, the request for admissions, those are all part of the discovery process. And your attorneys, when they represent you, will also send those types of things to the plaintiff to find out information about who the plaintiff is, what their medical bills are, what the injuries they are claiming are, if they claim they've missed work, and any amounts of compensation that they think that they're entitled to, as well as some background information on them and what their version of the accident is. Other ways of finding out information about an incident are through depositions, where the parties' attorneys can ask questions under oath of either the parties themselves or people who aren't parties to the lawsuit. That's why I mentioned before that it is important that we get all the information right at the time of the incident as to people, their names, their contact information, so that if the need arises to get discovery information from them later on, if a lawsuit happens, that we have the ability to go ahead and do that, and that we're not stuck with a set of facts because we can't find somebody now, or something, a piece of information we had at the time we no longer have. So all of those things in the front end are done in anticipation of this worst case scenario of a lawsuit getting filed and us having to defend against injury claims. Now, all of this, and it's rare, as you probably well know, it is rare nowadays that cases do go to trial. Most cases resolve outside of court, outside of trial, but it does happen. And that means that when a lawsuit is filed, your attorneys are going to be preparing as if the case is going to trial. And that's why things are done, such as the depositions, or the interrogatories and requests for documents. All of that is done in the event that we do get to a trial. Now, in Georgia, in civil litigation, you as the business have a right to a jury trial, a jury of your peers in the county where the case has been filed. 12 jurors can be selected through a process that we call jury selection, or voir dire, where we go through, and you may have sat for jury selection before, of 30 or 40 people who come in for jury duty, and the parties basically select or deselect a jury of 12 people that will sit and hear the case. And when the jury hears the case, they come to a verdict, and the verdict must be unanimous. All of the work that gets done, whether it's at the time of the incident, in the time pre-suit before a lawsuit is filed, and the time including the lawsuit, this is all done by the attorneys and the insurance company in preparation for a time if it happens that you have to go to trial. All that is done to prepare for trial and ultimate resolution of the case. I know I've covered a lot of information, and I've tried to give a very broad overview, but I cannot stress enough that even though this is not something that I know you do not want to occupy a lot of your time with, and that you have missions and your businesses that you run every day, and that this is not and shouldn't be a major part of it. But small things can be done now in preparation for the event that you have to deal with something like this. Because in dealing with people in your businesses, either nonprofits or for-profits, I know firsthand that nobody wants to deal with this type of stuff. No one wants to deal with a lawsuit. No one likes getting a call from their attorney to answer questions about information or having to go back and trying to find documents. All of that takes you away from running your business. And so we can prepare now, proactively, for when this happens. And it will likely happen at some point in running your business. We can just be better prepared to really minimize the risk and exposure to your business. So if anybody has any questions, I'm happy to answer.
We do have a follow-up question regarding sidewalks. You had mentioned sidewalks between kind of the building and parking lot. What is there a difference for sidewalks that run along the street that are kind of like the neighborhood or community access sidewalks?
Well, a lot of that depends on, I guess, the situation where if you own the property, the duty may be different than if you're simply leasing the property. If you own the property, I would say you have a duty to keep the premises, including the approaches, those sidewalks. Even if they are by the neighborhood, you have a duty to keep them safe. Okay. Even if it's, and I would say err on the side of caution, that if it's owned by the city or the county, still be cognizant of those hazards and notify the city or notify the county to make those repairs so that someone can't come back later and try and claim that you knew about something and didn't do anything about it. Sidewalks that I have this situation now where there's a store, and under the lease agreement, the business manages the store, but the landlord, the property owner, has agreed to maintain the sidewalk between the store and the parking lot. Now, this won't stop somebody from filing a lawsuit and claiming that the business should have known that there was a problem with the sidewalk between the store and the parking lot. But it is, if you have that type of agreement with your landlord, it's that much more important that you either take the steps to fix that hazard or make sure you're notifying them to go ahead and have it fixed.
And you had mentioned that if an injured party gets an attorney, after the attorney reaches out to you, the nonprofit shouldn't communicate with the injured party. But yes. What about if they haven't retained an attorney yet? Like if a week later, the injured party contacts a nonprofit and says, I was hurt here. Do you have any suggestions for what a nonprofit should do? Should they communicate with the injured party? Would it be better to go ahead for them to proactively retain counsel?
I think it would be a good idea if in the instance where the injured party calls you up a week later and says, I've been injured, to be very polite and courteous and get as much information as you can as to their injuries and their contact information, so that you can pass that along to either your attorney or in your insurance carrier. It's good to get information. If you have counsel or an attorney that you already have retained, you can tell the injured party that you have counsel. But I think getting information from them is a good idea.
Okay. And a general question is, yellow caution wet floor signs, are those considered to be a reasonable defense?
They can certainly help, because it goes to show that you're taking steps to try and notify people as to certain hazards. Obviously, you can't have those yellow signs unless you have employees walking around conducting some type of inspection, or if someone brings it to your attention that you've done something proactively to try and address that. So I think they can certainly help. I don't think it's not necessarily an absolute bar to anybody making a claim. Our legal system provides that anybody can file a lawsuit and make a claim. But in terms of making sure we've done everything we can to defend against these things, I think those signs can be helpful.
Well, that's all the questions we have. Wait, there's one more. If you receive a group of volunteers at a public storage facility, do you have the same level of responsibility for the volunteers, or is the landlord responsible?
I think that depends on who's running the facility. If it's your business that's running the facility, you have the same duties to the volunteers, and the landlord necessarily, they may claim that the landlord has the duties, but at the end of the day, how it affects your business, if your business is the one doing the operating and running the program, then you're the one